handgun, or it's abbreviated as LTC. It is not a concealed handgun license. That is an old terminology. So this is a LTC and not a CHL. And why is that determination important? It's because now, as of 2016, there is not a distinction primarily in the license to carry a handgun between a concealed carry and what's called an open carry. And so a concealed carry is as it sounds, it is concealed on a person. It is outside of view. And so that may be concealed inside a waistband. It might be concealed inside a purse. It might be concealed inside a boot. It might be concealed inside a jacket, but it's concealed. It's not supposed to be visible to someone else. An open carry allows for the carry of a handgun by a license holder in certain places, as long as it is in a belt holster or a shoulder holster. That is what the statute says. So again, that's very, very important distinction. Now that doesn't say what kind of holster that it is in. Does it have to have a? It doesn't. There's no description about what type of material that it would be made out of. There's no description about what the condition of that handgun, whether it's concealed or open, is in. There's no distinction whether it's chambered, loaded, safety on, safety off, cocked, however you want to describe it. So again, that is something that is important. In many ways, a license to carry is very similar to a driver's license in Texas. They're both administered by the Department of Public Safety. They look very similar to each other. Typically, the picture might even be the same. And most importantly, it's becoming kind of a rite of passage. Just like getting a driver's license might have been when someone was 16 or 17. They're excited about taking the class and excited about what they're going to do with this new license, the new freedom. The license to carry is becoming that same right, where people, they're talking about getting it. They're talking about what they're going to do with it. Most importantly, number 4 in here is each one has a procedure for suspension and revocation. And that's something that a lot of people think that just because it sounds pretty easy to get a license to carry, and in some respects that is the case. Assuming that you're of the proper age and you do not have any negative things in your background, you pay your fees, you take your 4-hour class, you pass your basic proficiency test, you get your clearance, and your license comes in the mail. And so, just like getting those 4 wheels of freedom when you're 16, you now have this new ability to carry a handgun in a number of places in Texas. Probably the most significant thing that people are aware of right now are the signage prohibiting the carry of a license. Prohibiting the carry of a handgun by a license holder in certain places. This is what is referred to as a 30-06 sign, based on the Penal Code, which is section 30.06, related to concealed carry. And if you see as it says, in red, a concealed handgun. And now there's another very similar sign, which is the 30-07 sign. Pursuant to section 30.07, holder with an openly carried handgun. These are 2 different signs. These signs, this is just an example of the sign. The sign is required to be posted in a prominent place. It's required to be in English and Spanish in letters at least 1 inch high, and posted outside of businesses that would restrict the carry of weapons in that place. Did anyone notice any signs when they walked in here today? What did we see? We saw both signs posted just to the left of the front sign. So what that means is that both the concealed carry of handguns is on notice as prohibited here, as well as the open carry of handguns in this place. Now, for example, if you were to go to Whataburger, and you would just see one sign there. That's the 30.07 sign, which is against the open carry of handguns. So what that means is that you could have the concealed carry of handguns inside a Whataburger, and so both signs would need to be posted to have the prevention. And so, as a result, there becomes a special violation, if you will, for a license to carry holder. That's called the unlawful carry of a handgun by a license holder. So that's something that only a license holder could get in trouble with. And in general, we have restrictions on location. We have restrictions relating to that signage. We've discussed the plain view and to some degree and the concealed. Most important thing with a license holder is that a license holder may not carry a handgun while they are intoxicated. So for example, if a license holder is arrested for driving while intoxicated, they have a license to carry. They have a handgun with them. They're going to have two charges now: one for driving while intoxicated, one for the unlawful carry by a license holder. That intoxication could also relate to a Class C misdemeanor of public intoxication. So also, of course, intoxication can be by other substances other than alcohol. And as we also move on to another section, also a broader section prohibiting carry of weapons. Weapons being a broader term to include rifles, shotguns, in addition to handguns. No person may carry a weapon when they're in the midst of a criminal activity other than traffic or boating, for example. So, if a person might have possession of marijuana and they have any sort of weapon with them, again, there's two charges associated with that. And if you look at the criminal activity aspect, other than traffic or boating, that is very broad. You know, that's covering the entire waterfront, all sorts of additional Class C misdemeanors, for example, any sort of, might be any sort of disturbances that we might have. And so, as a result, we have a suspension procedure for a license to carry a handgun. And so, for example, if a person has there are four significant aspects where a person could have a license to carry suspended. And the main aspect of that is that if there is a charge against them, not a conviction, but a charge of any felony charge, that seems pretty obvious. Any Class A misdemeanor charge, that seems pretty clear. Any Class B misdemeanor charge. These are not convictions; these are charges. And also a charge under Texas Penal Code Section 42.01. Section 42.01 is the disorderly conduct statute. There are over 10 items in there, most of which are Class C misdemeanors. But any sort of charge relating to that is going to result, and you'll see in your papers, you get a notice from the Texas Department of Public Safety. It has come to our attention that you have been charged with the crime of disorderly conduct in McAllen, Texas on December 31st, and you are now, your license is subject to being suspended unless you request a hearing. a license suspension. A license suspension hearing for a license to carry generally makes a suspension hearing for a driver's license look pretty extensive. It's very much, is there a charge? Case closed, so to speak. So again, if you take away nothing from this, remember that these charges under this disorderly conduct are very large, and any sort of plea of guilty to that, for example, is going to result in a suspension of a license to carry, which might be much more important to the person than the underlying charge. If I could show you just a little wheel of the suspension procedure. When you have either this charge, you've got perhaps this misdemeanor charge, some Class C misdemeanor charges, and I say that very significantly because as a program attorney for the Texas Law Shield that gets referrals into this area, 60% of the cost to Texas Law Shield involves some form of road rage. So all sorts of disorderly conduct, offensive gestures, abusive language, the display of a firearm, certainly any sort of discharge of a firearm. Those are all things that generally are going to happen in a driving situation. These things do not occur in the classic, someone was trying to break into my house, can I shoot them? It is not that. It is not that. It's much more benign. It's, hey, he bumped into me. We got an argument at the barbecue. The neighbor was making too much noise. So as I noted, you have the notice of suspension, the hearing scheduled, the suspension. If there's a conviction, you will have this suspension. If a person has their license suspended, they will not be able to reapply for a license to carry for at least 5 years. And again, it reflects back to if I could go back to the beginning slide, you can see that when you're obtaining a license to carry, if you look at the blue slide in the middle, not convicted of a Class A or Class A or Class B misdemeanor, or the purple one, not convicted of a charge under the disorderly conduct. So you've got that conviction. You've got to wait 5 years until after that conviction. And then you've got to wait another 2 years because there's a penalty in addition to that 5 years. So it's a 7-year period before you are able to get that license to carry back. So again, just like some of the things that have been being talked about, advising the clients as to the effect of a guilty plea under these things is going to be very important. Because the unexpected suspension of a license to carry that might have been very important to that person to obtain sometime before could result in some. You certainly never want to have those unexpected items occur. This is a broad topic. We've just touched some of the basics, but again, knowing about that suspension procedure is important. And also advising your client that again, there's many other misdemeanors that might happen where if they plead guilty to that, it might not have anything to do with their carrying of a weapon. It might not have occurred at the same time, but it can still result in a suspension of that license to carry and that 7-year waiting period to obtain that again. Thank you very much.
Mr. Turley? I have one question, Larry. Let me ask this and then we'll do you and then we got to shut it down. Can I get my guy deferred adjudication on any of the things on that list there and keeps his license, or deferred equals you're gone?
Well, again, that's probably where you really have to look into the real specifics of what exactly you're pleading to and what exactly is involved in that deferred. Some of the discussions earlier related to whether you were actually entering a plea of guilty in front of the judge or if you just had an agreement with the prosecutor. Yes, sir.
What happens if the criminal charge is dismissed before the suspension hearing?
Then you're golden, because then that is your goal, because then now you have not been convicted of a charge. And under the government code, you do not have a charge against you. So just as the charge against you resulted in a suspension of the license to carry, when the charge is dismissed, you don't have a charge against you anymore. And so therefore, you can simply call up your friendly attorney at the DPS, send them all the appropriate papers that the case was dismissed based on your wonderful lawyering, and the license will be reinstated.
Does the DPS have the burden of proof at the suspension hearing?
To call it a burden of proof at the suspension hearing is a great overstatement. Again, there are more than one ways of having a suspension. It generally does result in a charge against that, and generally no one needs to have a long evidentiary hearing about whether there's a charge or not. It's kind of like if you're pregnant.
Santos, can you get the staff, we're gonna stick a USB in?
Again, thank you very much. All my contact information is here. If you have any questions, I'll be around till the end of the day. Thank you.
For those of you that don't have a TV, maybe you don't know this young man just walked in front of me, but Renee Flotis, one of our premier lawyers, gets the worst ones, and he does quite well with them, and he gives his heart to it, while he tries to raise a number of kids and keep a wife at the house. Renee,